said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the
Don't
testimony.
get brazen with me.
Police officers might believe they hold unlimited authority, but once they step into a courtroom for their own crimes, judges waste no time putting them in their place. But starting off, we have an attorney who was completely owned by the judge.
A routine court trial heated up when Kenosha County Circuit Judge Bruce Schroeder scolded Assistant District Attorney Thomas Binger for trying to question defendant Kyle Rittenhouse about evidence that had been ruled out. Rittenhouse faced charges for 2 men and wounding another during a protest in Kenosha on August 20th, 20.
You indicated that at no time did this gun, this AR-15, ever leave the state of Wisconsin. Is that right?
Other than the night after, other than that.
Before the shootings?
Correct.
There was a time, though, where you wanted to have it with you down in Illinois, isn't it? It wasn't there?
I believe there was a time when me and Dominic were mad at each other. Yeah.
You were mad at Dominic?
Me and Dominic were mad over something.
And you wanted to have the gun with you down there?
I think I said something along those lines.
You back up for a second here. You have testified to this jury that you used deadly force against Joseph Rosenbaum, Anthony Huber, the man who attempted to kick you in the face, and Gage Grosskreutz on the night of August 25th, correct?
Yes.
And you did that because you felt that your life was in danger from those 4 people, correct?
Yes.
And you are telling this jury that it was, in your mind, justified to use deadly force to protect your own life, correct?
Yes.
You'd agree with me that you were not allowed to use deadly force to protect that CarSource building, correct?
Well, I wasn't using deadly force to protect the property. I used deadly force to protect myself, so.
That you were not allowed to use deadly force to protect that CarSource building, correct?
Yes.
You'd agree with me that you were not allowed to use deadly force to stop someone from smashing the windows of an unoccupied parked car, correct?
I don't think you could use deadly force for that.
You'd agree with me that you can't use deadly force to stop someone from lighting a metal dumpster on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone from tipping over.
Correct.
You'd agree you can't use deadly force to stop someone from lighting a flatbed trailer on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone who is about to start an unoccupied car on fire, correct?
Correct.
It looked ridiculously stupid that the prosecutor brought up evidence that had already been ruled out. It was hard to believe Binger even went to law school after that blunder.
Do you understand that there's a difference between using deadly force to protect yourself and using it to protect property, correct?
Yes.
And you'd agree with me that you're not allowed to use deadly force to protect property, correct?
Yes.
But yet you have previously indicated that you wished you had your AR-15 to protect someone's property, correct?
I'm going to ask you to go into the library again for a moment, please. Please don't talk about the case. Mr. Richards?
Your Honor, Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an
Mr. Binger? First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
The defense could see that Prosecutor Binger was ruining his own case by clashing with the judge. All that arguing was seen as extremely disrespectful and only made Binger look worse.
In my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. Yeah, that's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest that anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
The defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he's acknowledged that he told the person in the yellow pants, yeah, you're right, I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property. It goes...
He had the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is. I want...
May I respond to what you just said, Your Honor? I'd like to respond to what you just said. I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay. I believe that there is a central part of this case that Mr. Rosenbaum is making threats that he has no ability to carry out.
The prosecutor should have been disbarred for his outrageous behavior. He seemed to be trying to provoke a mistrial by challenging the defendant's right to remain silent. Judge Bruce was right to yell at him. His actions were completely unacceptable.
This case is about someone who didn't have a weapon, and yet the jury is being told, because of those threats, that means the defendant has to defend himself. So, with all due respect, Your Honor, mere verbal threats have already been shown to this jury and used as a basis for someone's subsequent actions. I am attempting, with the defendant, to use his mere verbal threat on August 10th, 15 days prior, that he's going to shoot shoplifters with his AR-15 to impeach the defendant in a murder trial. I would ask the court's forbearance to do that. I apologize, Your Honor. You're right. I probably should have brought this to your attention earlier. I may have misunderstood your ruling because I made that more relevant. You would admit it, or at least consider it an admittance. And I continue to believe that his state of mind, his intent, his belief as to self-defense is the core of this case. That was the basis for my motion. You were strongly inclined against it. I understand that. But now we're in the middle of trial, and there's been a lot of evidence that's come in that I think makes this relevant. So I'm attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call...
His statements do, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's prior, the reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop, and he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence.
Binger struggled to prove Rittenhouse's guilt, but the judge remained professional and honest, upholding the principle of innocent until proven guilty.
I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities. Wigmore and evidence. Judge Weinstein. Colonel McCormick. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense. That's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in. No matter what you think. With what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
It was hilarious watching Schroeder repeatedly explain the laws and rules to the prosecutor, who still didn't get anything right. Binger made so many terrible mistakes during the hearing. Schroeder and Binger clashed repeatedly during the trial. Schroeder slammed Binger for violating Rittenhouse's right to remain silent and for bringing up evidence that had been ruled out. Binger later accused Schroeder of unfairness in handling evidence. Despite Binger's promise not to comment after the verdict, Rittenhouse was acquitted on all charges 3 days later. We often see cops afraid of being filmed. This next case shows exactly why.
Do hereby find the defendant Michael Amiot guilty of a misdemeanor of the first degree.
In August 20th, 17, Officer Michael Amiot faced charges for a brutal traffic stop where cell phone video showed him repeatedly punching Richard Hubbard after pulling him over. During the trial, Amiot was convicted of assault, interfering with civil rights, but he was cleared of a second assault charge.
You may be seated. Ladies and gentlemen of the jury, you've advised the bailiff that you've arrived at a verdict. Have you arrived at a verdict?
Yes, sir.
If you would, please pass it to the bailiff. The heading in the Euclid Municipal Court, Cuyahoga County, Ohio, State of Ohio, plaintiff. We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot not guilty of assault a misdemeanor of the first degree in violation of Section 2903.13A of the Ohio Revised Code as charged in Count 1. We do so render our verdict this 29th day of July, signed by all 8 jurors. Verdict. We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of assault, a misdemeanor of the first degree, in violation of Section 2903.13A of the Ohio Revised Code as charged in Count 2. Verdict. We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of interfering with civil rights, a misdemeanor of the first degree, in violation of Section 2921.45A of the Ohio Revised Code as charged in Count 3. We do so render our verdict this 29th day of July, 2022. Signed by all 8 jurors. Ladies and gentlemen of the jury, are these your verdicts?
Yes, sir.
On behalf of the state, do you wish the jury polled?
No, Your Honor.
On behalf of the defendant, do you wish the jury polled?
Yes, Your Honor.
Juror number 1, is this your verdict?
Yes, it is, Your Honor.
Are these your verdicts, I should say?
Yes.
Juror number 2, are these your verdicts?
Yes.
Juror number 3, are these your verdicts?
Yes, Your Honor.
The judge showed zero sympathy for the killer cop, making it clear that no badge could shield him from justice.
And further of the jury. Ladies and gentlemen of the jury, I want to thank you all for performing your civic duty. One of the things that I will say is that you've done your job. You came, you heard the evidence, you applied the law, you made a decision. The prosecutor had a job, the defense attorney had a job. Your job was not to prove anything or disprove anything. Your job was to determine what was presented to you, determine the facts, apply the law, render a verdict. You did that. You should leave feeling that you've done your job. No second guessing, you've done your job. If someone else didn't, that's not your job. You've done it. If you'd like to hang around a few minutes and talk with me, I will do that. If you do not, that's entirely understandable. Sometimes the lawyers would like to talk with you to determine how they came across to you, but again, that is your decision as to whether you wish to speak with them. With that, anything prior to discharging the jury?
No, Your Honor.
On behalf of the defendant, anything?
No, Your Honor.
Ladies and gentlemen of the jury, thank you very much. You're discharged at this time. If you want to wait in the jury room, I'll meet with you later. With that, you're discharged. All rise. You may be seated. Based upon the verdicts rendered by the judge, the jury, the court at this time will enter on, with respect to count 1, a finding of not guilty, count 2 and count 3, the court will enter a finding of guilty. The court will set this matter out for sentencing, given the fact that under Ohio law, the victim has the right to make a statement or present anything he may wish to present to the court. The court will request the Cuyahoga County Common Pleas Court Probation Department to submit to the court any documents or any information that it wishes to submit with respect to pre-sentence investigation or what have you.
The verdict was based on video evidence from citizens, proving why it's crucial to record police interactions. Cameras don't lie, and it's clear why cops are often afraid of being filmed.
It's under the judge. The judge recused himself. It is better that we maintain the appearance of appropriateness in requesting that that be done by the Cuyahoga County Common Pleas Court. Anything else? The court will consult with the attorneys and the court administrator and set this matter over for sentencing at a date that's agreeable for everyone. Anything else on behalf of the state?
No, Your Honor.
Anything on behalf of the defendant?
No, Your Honor.
If there was a bond or no bond, it'll continue as stated. I want to thank everybody for their conduct. I know it got a little contentious at time.
The other officers in the hearing were stunned. It should have served as a wake-up call that cops could no longer escape accountability for their actions. Amiot was sentenced to 1 year of non-reporting community control and fired from the Euclid Police Department. He was later reinstated to the warrant unit. Richard Hubbard received $450,000 in a legal settlement. It was later found out that Amiot had a history of excessive force complaints and had resigned from a previous police job as well. Being a cop means catching criminals, but this next officer became one instead.
I'm about to hurt you.
On October 27, 2018, Daniel McKenzie, Mario Godoy, a 32-year-old suspect who had already been handcuffed and placed in the back of a police vehicle for trying to break into cars at a Roswell apartment complex. McKenzie teased and punched the handcuffed suspect, admitting to the assault during the investigation. He resigned from the Roswell Police Department shortly after. McKenzie was arrested on February 28, 2022, and later sentenced to 12 months in prison for battery and simple battery. He also received 5 years probation for aggravated assault, making a false statement, and 2 counts of violation of oath by a public officer. No one can escape justice, not even cops, as this next case proves.
Kevin Perez committed a battery upon him, so he won't have to account for his own behavior.
A jury of 3 men and 3 women found Miami Beach police officer Kevin Perez guilty of simple battery, a first-degree misdemeanor. This verdict came after State Attorney Catherine Fernandez-Rundle emphasized that the guilty verdict was a strong message against excessive force in arrests. Perez could face up to 1 year in jail, 12 months probation, and a $1,000 fine. Initially charged with third-degree felony battery, which could have led to up to 5 years in prison, the prosecutors couldn't meet the required standards for that charge. The charges stemmed from an arrest incident on July 26, 2021 at the Royal Palm Hotel, where Perez was accused of punching a tourist. Although Perez was found guilty, the judge granted him a new trial, with sentencing still pending.
This case is about the beating of an unarmed, handcuffed black man, Delonta Crudup, by an overzealous police officer, Kevin Perez.
Delonta Crudup has every incentive to say that Kevin Perez committed a battery upon him, so he won't have to account for his own behavior.
It is very, very obvious what he has on his mind, and it's retaliation.
Maintaining decorum in court is a cop's duty, but these next 2 did the exact opposite. At the Tonawanda City Courthouse near Buffalo, New York, a routine day turned chaotic when a dispute arose between Officer Michael Lewandowski and a couple. Lewandowski reportedly ordered the couple to leave, but they refused. He then forcibly removed the man from his seat and shoved the woman against the courtroom door. In the hallway, Lewandowski struck the man and slammed the woman's head into a cinder block wall. Despite her protests, both were handcuffed and taken away without charges or explanations. Lewandowski was initially suspended for 10 days for excessive force, but this was later reduced to 5 days after he agreed to bias training. The surveillance footage, not released at the time, came to light 4 years later, showing further misconduct. Consequently, the Tonawanda Town Board decided to fire Lewandowski after 4 years. As a cop, you're supposed to resolve conflicts, not create them, but this next officer chose to go violent over personal matters.
I was never ever expected to be grabbed from the back and thrown from side to side, to a point where I was yelling at the top of my lungs, help, help.
Former Miami police officer Lester Bonen Bliss, 51 years old, was sentenced to 45 days in jail, 3 years of probation, and 100 hours of community service for assaulting nurse James Nicholson at Jackson Memorial Hospital in May 2018. The altercation began when Bonen Bliss's niece was denied readmission after being discharged. Frustrated, Bonen Bliss arrived in uniform, and when Nicholson refused to discuss the patient, grabbed him and slammed him to the ground. Bonen Bliss accepted responsibility in court, but Nicholson stated the attack should never have happened, especially to a healthcare worker.
I was never ever expected to be grabbed from the back and thrown from side to side, to a point where I was yelling at the top of my lungs, help, help.
From catching murderers to trying to become one, this next cop took things to a whole new level.
Spanning from 1998 to this year represents the worst that we could possibly expect from someone in our society.
On May 23, 2013, former Edison police officer Michael Doro set fire to the home of his superior officer, Captain Anderko, while the captain, his wife, 2 children, and 92-year-old mother were asleep. Fortunately, no one was hurt in the 4 a.m. fire. Doro was arrested and, after a long trial, sentenced to 20 years in prison for attempted murder and aggravated arson. He will have to serve 17 years before being eligible for parole. In addition to the 20-year sentence, Doro received 10 years for official misconduct, 5 years for conspiracy to tamper with a witness, and 18 months for conspiracy to retaliate. He will also face 5 years of parole supervision after his release and is banned from contacting the Anderko family or any other victims. Throughout his sentencing, Doro showed no remorse and said nothing in court.
Understand where I'm coming from with regards to this, especially if there's going to be any appellate review of this sentence. I want those judges to know the sentence to be imposed in this particular case is because Mr. Doro, through his conduct and his admissions, spanning from 1998 to this year, represents the worst that we could possibly expect from someone in our society. Yes, he's caused very specific damage to Captain Anderko and his family, to Ms. Zog, to Ms. Doro, to his own parents, to his families, to his brothers. But what he's really done, and what we're going to be left with after he's walking out the door to spend the next third of his life in prison, is allow people a basis to say that our system of justice has no integrity. How could it when we've allowed this particular individual like him here in Middlesex County, here in Edison, to do the things that he's done?
How did Michael Doro's actions and sentencing impact the perception of accountability within the police force?
Moving on, watch how these cops completely broke down, unable to control their emotions as they realized their partner was a killer cop, now facing life in prison.
I'm thinking we're supposed to be the good guys. He's supposed to be watching back.
Count 1, capital murder. 2, a term of life without the possibility of parole.
Starting up, we have the case of a Border Patrol agent, Ronald Burgos, who committed the unimaginable act of murdering his baby mother, Griselda Hernandez, and their toddler son. Here's the testimony of the Border Patrol agent who arrived at the crime scene first.
The person that was using that car at the time was supposed to meet a Border Patrol agent at the Father Magnoble Park.
Okay.
The transmission that came in was the boyfriend's name was Anthony Burgos.
Okay. And explain to the ladies and gentlemen of the jury the exchanges that happened at that time.
So when Anthony Burgos, when the radio transmission came up for Anthony Burgos, there was only one Border Patrol agent that was at that location with us. I had just seen him. I had never seen this person before. I see him. He's right near the car, and so I wave him over. I say, "Hey, come here." As he's walking up to us, the name says Burgos. So we look at the name. I'm looking at the name as he's coming over, and I'm just like, "Hey, what? I think this is the person they just called over the radio." But they said Anthony, and I look at the first name, and it's an R, Burgos.
Shockingly, just minutes after committing the murder, Burgos was caught on the crime scene but was trying to evade accountability. Watch as the Border Patrol agent explains how they ultimately tracked him down.
So we all knew that his name was Burgos, but he had the R in front. So Detective Reyes tells him, "Hey, what's your name, man?" And he says, "Ronald Burgos." And we're looking for Anthony Burgos. And radio transmissions are coming through, and so it's kind of getting a little hectic. Burgos approaches closer to Reyes. I'm walking next to him. I'm the only uniformed officer, so I'm right next to him, and he says, "Hey man, what's your name?" And then Burgos says, "Ronald Burgos Aviles." He only uses his last names. So then Rick's like, "What's your name, dude? Why are you not telling me your name? What's your name?" And he says, "My name's Ronald Burgos Aviles." And he says, you're not telling me your name. Do you have an ID or something?
Burgos was eventually detained by the responding officers. He showed little to no remorse in the courtroom and was still denying the murders.
The unit was not there when this initially happened?
Correct. It was not.
Did you or did Detective Reyes secure him or check to see if he had any weapons, or what did you do?
Yes. So once I took the belt off, I put it behind his unit, and then I patted him down as the unit approached us. So I patted him down. I located a phone on him and a driver's license in his shirt pocket.
Okay. So and what did you do with those two items?
I turned over the driver's license to Detective Reyes, and the cell phone I put it with his property that I had already taken, which was his Sam Brown. I put it in the back of his truck.
The prosecutor also presented dash cam footage showing the moment Burgos was arrested and placed in the back of the police cruiser.
He's wiping his arms. Looks like he's cleaning something off, or
Right before he wiped his arms?
he licked his finger.
Shockingly, the officer was licking off his fingers and wiping his arms, desperately trying to wipe off the blood of the victims. He had committed the horrible murders with a knife as he lured both of them to talk about their future. Little did the poor souls know, a man they trusted was about to become a predator.
Come on, man. Oh yeah, he could have just told me straight up, man. Instead of making me go forward. Embarrassing, big ordeal.
Burgos, however, had made another blunder. After taking the lives of his baby mother and his son, he called the deputies to report a murder. One of the first responders was Agent Francisco Lara, who later testified in court.
I look south and I see the silhouette of the young woman. So I completely forget about Mr. Burgos and I start running towards the victim.
See the victim?
As soon as I see the victim, I approach and I start yelling. Like, señora, despierta, estás despierta. Ma'am, wake up. Because at this time, all I see is blood. I told my trainee, I call him Schmitty. I like, Schmitty, is that what I think I'm looking at? And I see the silhouette and I immediately start running towards her. And that's when I tell him, like, I start yelling at her, estás despierta, are you awake? I asked Mr. Burgos, do you have any gloves? He's like, no, I do not. So I say, I don't have any gloves. And I asked my trainee, Schmitty, do you have any gloves? And thankfully, being the great agent that he was, he did have a pair of gloves. So he goes ahead and tells me, like, sir, I have gloves. So I take them both, I grab one, and I give one to Mr. Burgos.
Lara was petrified to see the wounds, as Griselda had been stabbed 27 times, while the baby was also struck twice in the body. How a father can do such a heinous crime is beyond me.
And I immediately check for a pulse. I don't feel a pulse. I look at my fingers and they're covered in blood because I checked her neck area. So I don't feel a pulse, so I immediately see her left wrist. It's facing up. I check her wrist, and again, I do not feel a pulse. Right away, I tell Mr. Burgos, sir, I think she's 10-7, which means that she's dead. And he's like, yeah, it looks that way. He's standing there. Not really, the supervisor normally takes control of the situation and radios in everything to the station. Once again, he's quiet. I'm the one relaying everything that I'm seeing to the station. I'm processing everything in, I'm taking it in, and I'm telling them what I'm seeing. And right away, I start telling the camera operator to start scanning the river. I tell them, scan the river, see if you see anybody going back.
Eventually, it was revealed that Burgos had committed these murders just so he can stop giving his baby's mother child support. Officer Lara, in disbelief, expressed his shock that a fellow officer could commit such a horrific act.
I'm standing next to the victim. I check her. Mr. Burgos is standing over here too, I guess on the other side of her. So I tell him she's 10-7 with me, she's dead. Radio everything in. I told base 2, I think she's dead. They tell me take a step back, trigger the crime scene. So before anything, I told my trainee, go to the gate and open it for the paramedics. He takes off. So before I take a step back, I'm surprised to see so much blood. So I grab my head and I'm like, where is all this blood coming from? So at that moment, Mr. Burgos is like, cuts in front of me. He's like, let's find out. He grabs her from the bicep area, grabs her from the hip area, picks her up, looks at her, puts her back down. He does that, and my eyes were wide open. I was like, what is going on? And I take a step back. At the time he picks her up, I could see the shadow of her face.
Officer Lara eventually couldn't even control his emotions, as he had an emotional breakdown right in court explaining how he felt about Burgos and the entitlement he showed throughout.
My team leader tells me, hey, we already activated the Border Patrol unions, the lawyers for you. Before you make any statements, we already got lawyers. And I'm like, we already made our official statement. He was surprised. He's like, oh, you did? I'm like, yes. He's like, before he hangs up, he's like, just so you know, there's a rumor saying that the dead woman is Burgos' side chick. I'm like, all right, 10-4, let me call you back. Tell him, I tell him, sir, we just heard a rumor that the dead woman is Burgos' side chick. The detective said, side chick, that's his baby mama. And there's a possibility the dead boy is his son. That's when everything just, I broke down is the word. Everything just, I felt like this weight on my shoulder and I started crying. Because there I am thinking.
Wait.
Here I'm thinking we're supposed to be the good guys. He's supposed to be watching my back.
Hold on. Give me 1 second.
And I broke. I was heartbroken.
1 second, Agent. Just going to question answer basis, Mr.
I'm good, sir. Thank you, Your Honor.
This was a truly inhumane act, and the Border Patrol agent deserved nothing less than the maximum sentence. The judge didn't waste any time in announcing it.
2018 CRA 852D1. In the case of the State of Texas versus Ronald Anthony Burgos Aviles, the jury has returned a unanimous verdict. I'm about to read the verdict of this jury on punishment as to count number 1. Special issue number 1 on count 1. Whether there is a probability that the defendant, Ronald Anthony Burgos Aviles, would commit criminal act of violence that would constitute a continuing threat to society. Whether taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed. Answer, yes. Signed by the foreperson of the jury.
As expected, the jury found him guilty of 2 counts of murder, and he was sentenced to life.
You heard me announce the verdict of the jury with regard to both counts of this indictment. It is now my job to sentence you in accordance with that indictment, with that verdict. Do you understand that? After being found guilty by this jury of 2 counts of capital murder, and after giving us the verdict that they have just announced, it is my job now to pronounce sentence. As to count 1 of capital murder, and as a result of the sentence of the verdict of the jury, you will be sentenced on count 1 as to capital murder to a term of life without the possibility of parole.
Burgos avoided the death sentence, but he would be spending the rest of his life in prison. Well, this officer did the unthinkable, but the next sheriff was rightfully humbled and owned in court.
Stay out here.
The sentences will be served consecutively for a total of 4.5 years, of which 3 years of imprisonment.
In May 2019, Sheriff James Luhan overstepped his boundaries and abused his power to save his dear friend, Counselor Philip Chacon, when the cops arrived at his home with an arrest warrant. Angered by his interference, the officers secured a warrant for the sheriff's phone and later showed up at his office in 2020 to confront him directly.
Morning, sir. Executing search warrant. Sheriff Luhan.
Search warrant for him or?
For the building as well. I have no idea. It's house. But no, just stay here. No, I can't have you enter the scene.
You guys are fucked up, man.
Let's get him on the opposite side of this truck.
Cody?
Let's go on the opposite side.
Why is that, dude? That's messed up, dude.
Sheriff. That's what I'm saying. Let's get him on the opposite side of this truck.
Well, you got Tabitha over there. They got the press out here taking pictures of me in handcuffs.
Luhan couldn't believe how a warrant was released against him. He and his fellow cops desperately tried to save him, but things had gotten too far now.
Push him around into the doorway. Yeah, push him around into the doorway. At least to the doorway.
Aye. This is ridiculous.
Hold on, we have press.
Keep him up there.
Come over here, sir.
Keep him up there.
Sheriff,
Stay out here.
Ah, Jesus. Really? You don't have to. Just stand. Just stand. Just stand.
Put him on this side of the truck. Put him on the outside of the truck.
It hurts.
They're loose, sir. They're loose.
No, they're not loose. Can you take these handcuffs off? They hurt. They hurt. Am I under arrest?
You're being detained.
Well, yeah. Why do I have to have cuffs on? They hurt.
The sheriff's corruption would have been exposed badly if the authorities had seized and checked his phone. Therefore, the corrupt sheriff started to resist the cops, creating a problem for himself.
25, do all units, make sure you guys stay running hot.
So on this is signed by a district court judge. Good. Okay. Judge Bonen, First Judicial. Okay. So this search warrant gives me the authorization to seize your phone. Okay. Search your phone. Okay. But it also gives me the authorization. So what I'm asking for you to do is unlock your phone, unlock it, give it back to me, and I'm going to remove the security settings. I don't want your passcode. I'm not asking for your passcode. I'm asking you to unlock the phone. For the search warrant, you can read it if you want under number 2.
I will if I get a chance to talk to my attorney.
It doesn't work like that.
Marty,
this is not a negotiation.
get off.
This is not a negotiation, Sheriff.
As expected, the sheriff refused to surrender his phone, prompting the deputies to arrest him on the spot and prepare to take him to the station for booking.
You can talk to your attorney.
Well,
this is all
I've
done.
been asking.
When this is all done, you can call your attorney. But right now, we're trying to get you to comply with the warrant. The warrant stipulates exactly what we want. Give us that. We'll get the phone. We're out of here.
Right now, I'm under arrest. Because I am under arrest. I am in handcuffs. I'm not free to leave. I'm not free to leave? Am I free to leave? No. Then, if I'm under arrest, I have a right to an attorney, correct?
You do.
Okay.
And I'm not questioning.
I'm invoking my right to an attorney right now. Okay. You understand that?
So, take him in.
Book me for
booking. For obstruction. Obstruction.
Book it. I'm not obstructing.
Take him over here to our unit. Take him over here to our unit.
Over here, Sheriff. Over here. Sheriff.
They're gonna book me.
Stop. Just walk.
The out-of-control sheriff finally learned he wasn't above the law, and it was undeniably satisfying to see him cuffed by officers far junior to him.
I'm telling you what the warrant stipulates. I understand that. I told you what the warrant stipulates. You have every opportunity to cooperate. You want to cooperate, you're going to jail. Have a seat, sir.
Alright, you good? Why is already
Take the whole thing off. No, I haven't been searched. Just take me so we can do it.
I want to make sure you don't have any knives.
I don't have any knives. I don't have any weapons. That's my wallet. My keys to my truck. I don't have any weapons. Okay? I really don't. You took my weapon. As a matter of fact, you left it on the back of my truck over there. You can get somebody to secure it, please.
We'll secure everything for you.
Can you move these to the front?
No, sir. Against department policy.
Well, it's tighter than hell. They hurt.
Sheriff, those are very, very loose.
Really?
Step up. Let me see if I can fix them. They're very, very loose.
Sheriff Lujan's deputies weren't too impressed either, and they even tried to fight against the Santa Fe deputies for arresting their boss. But these honest deputies weren't having any of it.
What do you mean everything? So this is what we took off this person? You're the one that took it off this person? Took it off this person. Deputy Graves. Well, inventory it before you get it. We're handing it right over to you. Inventory it.
We're trying to do everything peacefully. We tried to. Okay? That's all we're doing. We're done here. We're leaving.
Okay, well, get out of here then. You're done. Get out.
We'll leave when we're ready.
You said you were done.
Yeah, we're wrapping it up right now. You know how it goes. You know how it goes. We're doing our law enforcement duties. That's it. District court signed it. That's it.
Okay.
Okay, so as soon as we're done, we're going to get out of your hair. Why are you calling everybody here to put them in
our
bond?
house.
Well, right now it's ours. Right now it's ours.
Oh, wow.
We own the building right now.
Shut up.
Don't talk to me like that.
Shut up.
I don't work for you. Don't
Okay.
talk to me like
Shut
that.
up.
Easy,
Go over
easy.
there.
Get that and let's go. Are we done in there? Are we done in there? Okay.
Lujan's phone was eventually accessed, and as a result, he was found violating the department's policies. He was charged with intimidating a victim and aiding a felon. He was also immediately fired from his position, and here's how he was taken to the cleaners in court.
The people of Rio Arriba County elected you to be sheriff. They put their trust in you to uphold the law, and you let them down.
Yes, Your Honor, I try to do the best that I can to help everybody I can, and I in no way would want to.
You are not above the law, nor can you ignore the law when it serves your purpose. The sentences will be served consecutively for a total of 4.5 years, of which 3 years of imprisonment and 1.5 years supervised probation.
Was very arrogant, and he would use that power to interfere with other investigations that weren't his investigations.
You let down the people of Rio Arriba County, and you let down the Sheriff's Department, the department that you led. What kind of example were you giving the people that you supervise?
The sheriff served a few years in prison and was later released on probation, which he continues to serve to this day.
Well, that brings us to the end of this video. Today, we saw cases where power-tripping cops made some terrible decisions and were owned in court. Thanks for watching. Please support the channel by subscribing and leaving a like. Also, if you enjoyed this video, check out the next video here.